Hello everyone, welcome to Lukmaan IAS. Today we are going to have the Hindu newspaper analysis dated 21st of February 2024. In today's newspaper analysis, we are going to cover the most important articles from the newspaper, and also we are going to cover a mapping topic that will help you to solve map related questions in the prelims exam. So let us quickly see the list of articles that we are going to cover in today's newspaper analysis. So these are the list of articles that we will discuss. So in all we are going to cover about 9 articles and 1 mapping topic. So these articles are from the Hindu newspaper dated today. Okay. So this is the first topic that we are going to discuss. Name of this topic is India and Sri Lanka mapping. Okay. India and Sri Lanka map. So we are going to understand that part. So as we know that Sri Lanka is located to the southern portion of India. It is located to the southern part of India. And since Sri Lanka is located to the southern part of India, just a minute, okay. So since Sri Lanka is located to the southern part of India, right? So recently what has happened between India and Sri Lanka, some trade related ties have been signed, okay. So that's why we are going to see some geographical features associated with Sri Lanka and India. So Sri Lanka is a maritime neighbor of India. With Sri Lanka, India does not share exact land boundary. However, we share maritime boundary with them. So we are going to understand about some maritime features that are there. So between India and Sri Lanka, right, this is India and this is Sri Lanka. So between India and Sri Lanka, there is a narrow channel of water that connects two water bodies. This narrow channel of water is known as Palk Strait. P-A-L-K, Palk Strait. And this Palk Strait connects Bay of Bengal with Arabian Sea, right? It connects Bay of Bengal with Arabian Sea, and it separates India from Sri Lanka. So this strait is very important. The Palk Strait is very important. Now let us look at that map. Okay, we are going to now understand about the larger map of Sri Lanka to understand some feature, right? Some feature related to geographical part. Okay, so one thing is we discussed about Palk Strait. So this strait is a narrow channel of water that connects, let's say, like the Bay of Bengal with Arabian Sea, that separates India from Sri Lanka. Apart from this, we have a gulf which is known as Gulf of Mannar. Okay, Gulf of Mannar is located towards this side, the western side of Sri Lanka. Okay, it is southern part of India. And apart from this, there is a bay which is known as Parkway. Okay, Parkway. This is also important. So where is the capital of Sri Lanka located? Capital of Sri Lanka is located at Colombo. And Colombo is located in the western side of Sri Lanka. This is important. Apart from this, let's say there are some ports which are being built by China in Sri Lanka. So those ports remain in news, right? In your free time, you locate those ports as well. So sometimes, let's say they may be asked in the UPSC examination. Okay, so this is what we just wanted to go through the map of India and Sri Lanka, right? So rest of the portions we will discuss, let's say, in further discussions, right? So now let us quickly move to the first topic. This topic has been there in the editorial section, I mean like the bigger portion of editorial, which is known as text and context section. Okay, it is text and context section. So this article has been there. So name of this article is Why Are Farmers Protesting Again, right? Why we are talking about again? Because before this, in the year of 2020 to 21, especially in 2021, farmers have protested in huge number, and huge number of farmers have protested against the government. Why they have protested against the government? Because that time the government of India has introduced 3 farm laws or 3 farm bills, right? And those 3 farm laws, let's say, wanted to change some of the things related to, let's say, farming activity in the country. It could affect the farmers' livelihood. So that's why farmers have come on the streets to protest against those 3 farm laws, right? And these 3 farm laws have been mentioned in this article as well. So what are these 3 farm laws? One of the law is known as the Farmers Produce Trade and Commerce Promotion and Facilitation Act. This is one of the farm law, right, that was introduced by the government long back in 2021. And the second act is known as the Essential Commodities Amendment Act. Okay, second is known as the Essential Commodities Amendment Act. And the third is known as the Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Act. So these were the three farm laws that were introduced by the central government in 2021. However, farmers have protested against these laws because farmers felt that these laws are not going to help farmers in the long term, right, in the long run. So now farmers have come again on the streets to protest against it. So what has happened to these three farm laws? These three farm laws have been taken back, right? These three farm laws have been taken back. Taken back means these three farm laws have been repealed or rolled back by the central government. Now these three farm laws do not exist. However, during the protest of the farmers in the past, in 2020 to 21, the farmers have raised some demands to the government. What were those demands? One of the demand was inclusion of MSP, right? Minimum support price, right? So farmers wanted that minimum support price should be guaranteed by the government through an act. So as of now, if we talk about the minimum support price that exists in India, so initially the minimum support price, I mean, this thing has been, let's say, this thing has been introduced by MS Swaminathan committee. So MS Swaminathan committee has recommended the government that this should be the MSP price, minimum support price for the farmers. But the thing is, minimum support price is now calculated by Commission on Agricultural Cost and Prices. So there is a body which is known as CACP, Commission on Agricultural Cost and Prices. So this particular body actually, let's say, calculates what should be the minimum support price. After then, it recommends to the respective body in the ministry, and then they, let's say, announce the MSP. But the announcement of MSP and inclusion of those 22 to 23 crops, right? So they are not legally backed in the sense, like it is in the whims and fancies of the government. Sometimes the government, let's say, may announce for some of the crops, sometimes not. And in many of these states, all the, let's say, all the crops for which the government of India has announced MSP, these are not procured also by the government. Okay, so in some states 4 to 5 crops are procured by the government through the channels that the government has set up. So as of now, the farmers are demanding that it should be legalized. It should be legalized means there should be an act that should be made by the government for procurement of crops from the farmers at MSP rate. So they want that all the crops should be included under the MSP. So this is one of the demand of the farmers now. Apart from this, farmers are also demanding that all those farmers who are above the age of 58 years, they should receive pension. Okay. Apart from the farmers want that, there should be withdrawal of the Electricity Amendment Bill 2020. They want reintroduction of Land Acquisition Act 2013. So when we talk about Land Acquisition Act, right, so there was a LARR Act, Land Acquisition, Rehabilitation and Resettlement Act. So under that act, if government is acquiring land of farmers, so in that case, government will pay 4 times the price that is set, let's say 4 times the market price of the land to the farmers as compensation. So farmers want it to be brought back. Apart from this, farmers are also demanding that the farm loan waivers must be imposed. I mean, farmers should be given farm loan waivers. If farmers have taken loans, so that should be waived off by the government. Apart from this, farmers want 200 days of employment annually at daily wage of ₹700 under the Mahatma Gandhi National Rural Employment Guarantee Act. So these are some of the things that the farmers are demanding. So farmers are demanding a lot of things. One of the things is farmers are demanding that pension should be given, farm loan waiver should happen, and apart from this, farmers want that the government of India should let's say come up with legal guarantee for MSP, and they should procure all the farm output, let's say, at MSP rate. So as of now, what has happened, the central government, right, central government has recently, let's say, had 4 meetings with the representatives of the farmers, 4 meetings with the leaders of the farmers organization. So which organizations are participating in the in the protest? So one of the organization is known as Kisan Mazdoor Morcha, okay, Kisan Mazdoor Morcha, and second is Samyukt Kisan Morcha, non-political. So these are 2 farmers organization who are participating in the, let's say, protest. They want that their demand should be accepted by the government. And not only this, let's say during the interaction between the leaders of the farmers organization and, let's say, leaders from the political party, right? So the leaders from the political parties did not disclose about how the MSP will be calculated, whether they are going to follow the A2 plus FL plus 50% or they are going to follow C2, right? Input cost and rent of the land plus 50%, okay? So A2 plus FL plus 50%. So these are different methods of calculation of minimum support price, and the minimum support price in India is calculated by Commission on Agricultural Cost and Prices, okay? This is the thing. So these are some of the important part that like why farmers are protesting. As of now, most of the farmers who are protesting, they are coming from the state of Punjab. However, they have been stopped on the border between Punjab and Haryana, right? So they were not allowed to be to move further, and government of India has created barricades. I mean, like, you know, big barricades with lot of, let's say, mechanism have been employed over there. So even it is accused that police personals are using drones, right, to to throw the gases on the farmers, to throw, let's say, pellet gases, or to throw things on farmers. So these are the things that are happening. So as of now, the protests are still ongoing. We will see, let's say, how it turns, how the government responds to the demands of the farmers, and how farmers, whether farmers accept those demands or not. We are yet to see how long this the farm protests are going to happen. Okay, so with this, now let us quickly move to another article. This article is again important. In this article, we are going to discuss very important thing. This important thing is related to right of maintenance for a divorced wife. For example, let's say there is a couple, right? There is a couple. So one of them is husband, the another is wife. So the thing is, right, another is wife. So in case, let's say they get separated, in case they get divorced, so the thing is, the wife generally wives do not have any financial backing. So the thing is, they do have some right of maintenance, right, from their husband. But in this article, we are going to look it from a specific angle. So here we are going to talk about on the rights to maintenance for divorced Muslim women. We are going to talk about how Muslim women are treated, right? So are there any personal laws that are specifically made for Muslim women? Are they in sync with the constitutional norms? Are they in sync with the CRPC that is there? So here, to understand this article, you need to understand that, we do have Criminal Procedure Code in India, which is known as CRPC. Under CRPC, there is a specific section. Which is that section? It is known as section 125 of the Criminal Procedure Code in India. The section 125 of the Criminal Procedure Code in India talks about the, let's say, rights of the divorced women for maintenance from her husband, right? So CRPC is available to all the citizens of India, to all the, let's say, divorced women, right, in the country. So CRPC does not look into the religious identity, whether, let's say, the women is coming from a specific religious community, whether they are from Muslim, they are from Christians, they are from Hindu and all. So it is applicable. The Code of Criminal Procedure, section 125, is applicable to all Indian citizens. Specifically, it gives rights to women for maintenance who are divorced by their husband. This is the thing. However, when we talk about Muslims, right, so although the acts exist for other religions also, in this article the scope of discussion will be related to women who are Muslim and who are divorced. So in that case, there is an act which is known as 1986 Act, and name of this act is Muslim Women Protection of Rights on Divorce Act 1986. This is the full form of the act, the Muslim Women Protection of Rights on Divorce Act 1986. So when we talk about this particular act, this act puts a condition on the maintenance that the wife will be getting, right, that the wife, a divorced wife, will be getting from her husband, and that condition is known as iddat. Okay, what is that condition? It is known as iddat. So what is iddat? Iddat is a period, okay, it is a time period usually of 3 months which a woman must observe after the death of her husband or divorce before she can remarry. So let's consider, so we earlier discussed about this particular thing, that there is a husband, there is a wife, right, they get divorced. So after divorce, what happens? The wife have to mandatorily wait for 3 months, right? She has to wait for 3 months before she can remarry. And during this period, during this 3 months time period, what will happen? The women, the divorced women will be given maintenance by her husband, and this is, let's say, like, this is recognized under this act, which is Muslim Women Protection of Rights on Divorce Act. However, the provision of this act has been challenged before the Supreme Court of India time and again. In 2001, the Supreme Court of India had given a judgment, and in that judgment, the name of that case is known as Daniel Latif versus Union of India 2001 case. This is Daniel Latifi versus Union of India 2001 case. So in this case, what the Supreme Court of India has upheld, Supreme Court of India has upheld the constitutional validity of 1986 Act by extending the right of a Muslim woman to get maintenance till she remarries. Okay, it however reduced the period of maintenance to the completion of iddat. So here the Supreme Court of India has upheld the constitutional validity of this act. The name of this act is Muslim Women Protection of Rights on Divorce Act 1986. So the Supreme Court of India has said that this 1986 Act, Muslim Women Protection of Rights on Divorce Act, this is constitutionally valid, right? And so Supreme Court of India has upheld that Muslim women upon divorce has the right to get maintenance. However, Supreme Court of India has also observed that the time period will be of iddat, means this time period has been reduced. However, this act has again been challenged in the Supreme Court of India in the year of 2009. In 2009 also, Supreme Court of India has challenged this act, and the division bench of the Supreme Court reiterated that a divorced Muslim woman's right to claim maintenance under section 125 of the CRPC, section 125 of the Code of Criminal Procedure, as long as she does not remarry. Okay, so Supreme Court of India has said that a divorced woman will have the right to get maintenance from her husband under section 125 of the Code of Criminal Procedure, right? So she will be getting this thing as long as she does not remarry. If she remarries to another person, in that case only she will not be getting further, further maintenance from her previous husband. Okay, and it highlighted that such a relief would be extended even after the expiry of the iddat period. Now this 2009 ruling of the Supreme Court of India goes little further than the 2001 judgment of the Supreme Court of India. Okay, why? Because in this case they have removed the capping of the iddat period. Here Supreme Court of India has said that if the woman does not remarry, in that case she will continue to receive, right, maintenance from her husband. And how did the proceedings play out? So Supreme Court of India has, pointed out section 3 of the 1986 Act. Okay, in 2009, Supreme Court of India has looked into one of the section of the 1986 Act. What was the 1986 Act that we discussed? This is the 1986 Act. It is known as Muslim Women Protection of Rights on Divorce Act. So Supreme Court of India has looked into the interpretation of section 3 of this Act. And Supreme Court of India has said that this act begins with a non-obstante clause. What is this non-obstante clause? It means like it starts with notwithstanding anything contained in any other law for the time being in force. It means, let's say, if they are talking about this particular act, they are saying that although other acts may be there that may be related to the same topic, that may be related to, let's say, maintenance of women, but the thing is, still this act will be there. Like, this act will not, let's say, make other acts unconstitutional and all. So it starts with non-obstante clause, and thus it does not bar an alternative remedy under section 125 of the CRPC. Okay, so this is the thing. So this particular case is now being relooked. Okay, it is being relooked. Why it is being relooked? Because let's say now the government is coming up with various provisions that we will provide, let's say, benefit to the Muslim women. So now the question is that for Muslims, there is an act which is in place. This act has been upheld by the Supreme Court of India time and again through its judgment. However, is it right to give a precedent, right? To give a precedence to secular acts. Secular acts means section 125 of the CRPC, Code of Criminal Procedure. Okay, so is it right or not? So now here the question arises: secular acts versus the acts that are made for a specific religious community over here. Okay, so this is the thing. So with this, now let us quickly move to another article. Okay, we are going to move to another article. So this article talks about judicial clarity on free speech. Now, to understand this particular article, what you need to do, you need to understand that there was recently a judgment from a high court, and that high court is known as Bombay High Court. Okay, so from a Bombay High Court, a judgment came, and that judgment was from a divisional bench. In that bench, there were two judges. Okay, there were two judges. So Judge 1 and Judge 2. Okay, so a decision has came from the right of free speech, and so we are going to look into this particular judgment, and the author has, let's say, in great detail talked about, let's say, the judgment that was authored by one of the judge, and here name of this the judge is Justice Gautam Patel. Okay, so author is talking about Justice Gautam Patel. So here two judges have given a verdict, and it was a split verdict. What kind of verdict? It was a split verdict. A split verdict means both the judges have taken different opinion on the same matter. So it was kind of, let's say, so final award, right? It will go to a higher judge bench, or it will go to the Supreme Court of India as of now. But in this article, what the author has done, author has looked into the judgment of one specific judge, and author says that this judgment, right, the judgment that was authored by Justice Gautam Patel, this assumes very significant. Okay, this is a very significant judgment. Why? Because here the author talked about, let's say, one case which is popularly known as Kunal Kamra case. Which case? It is known as Kunal Kamra case, popularly known as. Okay, so this has to do something with fact check unit of the government of India. Okay, fact check unit. So long back, the central government in 2021 has notified one unit which is known as fact check unit. So what was the purpose of that fact check unit? Is that fact check unit will look into the contents that are available online, the contents that are available in social media platforms. If any of those content criticizes the government, if any of those content has false or misleading information related to the central government, in that case, the central government can notify that particular social media intermediary or that organization or that individual to take down that particular information, right, from the internet. So why it was brought by the central government? Central government said that we want to maintain, let's say, true information of the central government on the internet. So we want that all the false information that is available related to central government on the internet must be taken back. However, this let's say, establishment of fact check unit has some controversies associated with it. What controversies? Basically, this fact check unit is actually infringing upon the fundamental right of people to speech and expression. So we do have a right under Article 19 of the Constitution of India. This is right to the freedom of speech and expression. So we have the freedom of speech and expression. We can speak our mind, let's say, verbally, through writing, through videos, and through different channels, right? So if freedom of speech and expression is curbed through some of the notification of the central government like this, so it does have some constitutional repercussions. So now let's say a case was filed in the Bombay High Court, and one of the judge, Justice Gautam Patel, has taken an opinion. Justice Gautam Patel has held that this is unconstitutional, right? This particular thing. So the learned judge has said that in the social media also there is right to free speech for people, and so like reasonable restrictions that are put by the central government based on fact check unit, it is not constitutional. So author said that except reasonable restrictions thereon as envisaged in Article 19 Clause 2, Clause 6 of the Constitution. So these are reasonable restrictions. Apart from this, other things that the central government has mentioned in the fact check unit, like intermediary shall make reasonable effort by itself, these things, so they will not be like constitutional, they are unconstitutional. And here the author is also talking about some amended Rule 3 Clause 1B of the IT Rules 2021. So in this article, author, let's say, like praises or boasts, or let's say, like puts confidence on the judgment that is delivered by Justice Gautam Patel, because Justice Gautam Patel has upheld the freedom of speech and expression that is mentioned under fundamental rights under Article 19 of the Constitution of India, right? So here the author has, let's say, referred to few previous judgment of the Supreme Court of India. One of the judgment is known as Shreya Singhal case 2015, right? And there was a Zeran case 1997. So they are a frontal assault on the marketplace of ideas. Okay, so like they basically, what has happened, the Supreme Court of the Bombay High Court judgment in this case, although it was a split verdict, but the opinion of one of the judge actually upholds the freedom of speech and expression for the public, and they hold the fact check unit of the central government as unconstitutional. So this case will further go to a higher judge bench in the same High Court, or it may go to the Supreme Court of India. We are yet to see how it turns out. Okay, so with this, let us quickly move to another article. So this is another article. This article says having panchayats as self-governing institutions. Okay, so when we talk about panchayats, so the Union Government of India has, let's say, like enacted legislations in 1973. So in 1973 they have come up with, let's say long back, they have come up with 73rd and 74th Constitutional Amendment Acts. And this 73rd and 74th Constitutional Amendment Acts actually gives constitutional status to the Panchayati Raj institutions. Okay, so Panchayati Raj institutions have been made a constitutional body because it was enacted in the Constitution of India. So like through 73rd and 74th Constitutional Amendment Act. After then, the state of Rajasthan became the first state, right, in India to implement Panchayati Raj institutions, to give, let's say, like a validity to this particular thing by enacting, let's say, like Panchayati Raj institutions as constitutional bodies. So it has been 3 decades that let's say, like 73rd and 74th Constitutional Amendment Acts have been passed. But even after 3 decades, the Panchayati Raj institutions or panchayats, gram sabhas have not been empowered so much that they become self-reliant. So at this point of time, what has happened, although 30 years has passed, these Panchayati Raj institutions, panchayats, gram sabhas at local level, right, they do not have financial autonomy. Why? Because let's say, like many few states have given them taxation powers, right? Many few states have given taxation powers to them. Even if they have taxation powers, so many a times they do not impose taxes on the people. So they rely on the grants that they receive from the state government and the grants that they receive from the central government in this regard. Okay, so the Central Finance Commission has been, let's say, allocating funds to the Panchayati Raj institution from year on year. So in this article they have referred to, let's say, 10th and 11th Finance Commission grant, right, and also 14th and 15th Central Finance Commission grants. So these grants from the Central Finance Commission has increased over the years. Okay, these grants has increased over the years. So earlier when we talk about 10th and 11th Finance Commission, so what they have done, they have allocated 4,380 crore and 8,000 crore. However, in the 14th and 15th Finance Commission, so the allocation has increased to 2,202 crore and 2,80,000 and 733 crore respectively. So the thing is, the grants that are made, right, by the Central Finance Commission to the Panchayati Raj institutions, so they have increased enormously over the years. However, there is a very important thing for us to discuss. This is known as own resource of revenue. So what do we mean by own source of revenue? The own source of revenue is very important. Own source of revenue means when these Panchayati Raj institutions or let's say, like, these local governments, right, the Gram Sabhas, when they themselves impose taxes, right, on businesses, on individuals, right, on various things, and they generate revenue, so that is known as own source revenue. So what are the items on which they apply taxes? One of the item is property tax, cess on land revenue, surcharge on additional stamp, duty, tolls, tax on profession, advertisement, user charges for water and sanitation and lighting are some of the major own source of revenue of these, let's say, like, Panchayati Raj institutions. So here finally in this article, author says that, like, we need to come out of this over dependency syndrome. At this point of time, the Panchayati Raj institutions are dependent on the finances that they receive from the state government, are dependent on the finances that they receive from the central government. So they want to come out of this let's say dependency syndrome. So finally author says in this article that there is a need to educate elected representatives and the public on the significance and the need for panchayats to be able to survive on their own resources. So here author is focusing on the capability of the let's say local self-government, of the Panchayati Raj institutions to sustain on their own, to manage their finances on their own. If they are able to sustain on their own, if they are able to manage their finances on their own, so they will be more autonomous, right? So they will truly be the third tier of the government, which has been envisaged 3 decades back. Okay, so with this, let us now quickly move to the next article. So this is another article. This article is again important. It says keep it wholesome. Okay, keep it wholesome. So we are going to discuss about it. It talks about National Cervical Cancer Control Scheme, right? So basically why we are talking about this scheme, because recently the Finance Minister of India has announced something related to this scheme. So the Union Finance Minister Nirmala Sitharaman announced during the presentation of the interim budget that the government's plan to encourage vaccination against cervical cancer for girls aged 9 to 14 is no doubt a step in the right direction. While this scheme will be fleshed out post-election, it is also time to question if any program to handle cervical cancer would be wholesome if it did not assimilate. So here we are talking about the Finance Minister's announcement. Finance Minister's announcement related to this, let's say, National Cervical Cancer Control Scheme. So here we need to understand what do we mean by cervical cancer, right? So how we can control it, whether this cancer is, let's say, life-threatening or not. So when we talk about this cervical cancers happen to women, right? It happens to women. So this cancer happens, let's say, like, on the lining, right? So this cancer happens on the cervix, which is known as neck of the womb. Okay, it happens on the neck of the womb. And these cancers, right, so these cancers can be treated properly, right, with very less, let's say, like effort by the government or by the health authorities or by health agencies. So how these cancers happen? These cancers happen because of a virus, and this virus is known as human papilloma virus. Okay, in short it is known as HPV, human papilloma virus. Because of human papilloma virus, people, let's say, like, women may get this cervical cancer. And how human papilloma virus, let's say, infects people? So human papilloma virus is transmitted through sexual intercourse. Okay, so whenever there is sexual contact, right, if a person who is affected by HPV, human papilloma virus, so there is a likelihood that that person may transmit human papilloma virus to his or her sexual partner. Okay, so through this, let's say, like, cervical cancer happens, but this is a treatable disease, right? It can be treated. And so the treatment methods are also mentioned in this article. So they have mentioned, let's say, like, few names. One of the tests is known as VIA test, other is known as Willy test. So VIA and Willy tests are those tests that help, let's say, health authorities to identify whether a woman has, let's say, like, the cervical cancer or not. Okay, so after this test, they can follow, let's say, different treatment plans. And treatment is easy, it is not very difficult, it is not very costly. So the central government must come up with treatment plans as soon as possible. So with this, let us now quickly move to another article. Okay, we are going to go to another article. And this article talks about CALM assessment. So here we are going to discuss about this topic. Okay. So we are going to discuss about this topic, which says CALM assessment, clarity on the nature and extent of deemed forest. So to understand this article, we need to understand that recently what has happened, the union government has come up with an amendment to what? It has come up with an amendment to the Forest Rights Act or Forest Conservation Act of 1980. So the union government has amended the Forest Conservation 1980 in 2023, and they have named this act as Van Sanrakshan Evam Samvardhan Adhiniyam. So in the amended act, basically, let's say, apart from other changes, they have done one very big change, and the change is in the definition of forest. So they have said that forest will be considered all those places that are in the government records only. Okay, so government records means the that are in the records of the central government, that are in the records of the state government, or that are in the records of the local government. If a forest is not recorded in the government, right, list, so it will not be considered as forest. However, this amendment of the central government was in contravention, right, to the judgment that was passed by the Supreme Court of India in 1996. So the Supreme Court of India has passed a judgment related to similar matter in 1996, and that case is known as T.N. Godavarman Thirumalpad judgment. Okay, it is known as T.N. Godavarman Thirumalpad judgment. So what has happened in this judgment? Basically, in the state of Tamil Nadu, way back in 1994 or 1995, there were cases of timber felling. So huge number of timbers or trees were being cut. So there was a person who has filed a case, and that case has reached to the Supreme Court of India also, and Supreme Court of India has given a landmark judgment, which is now known as T.N. Godavarman Thirumalpad judgment. And in that judgment, the Supreme Court of India has said that we will consider all those places as forest that are, right, all those places are forest that are in the government, that are mentioned in the dictionary. I mean, like, so dictionary definition of forest will be considered as forest. It is not needed that, like, whether there is a mention in the government notification or not that this is a forest. So if a forest is classified as per dictionary definition, so that will be considered as forest. So the recent amendment of the central government is in contravention of the Supreme Court judgment. So now again recently the Supreme Court of India, people have criticized this amendment of the central government and they have moved to the Supreme Court of India for a remedy related to this. And what Supreme Court of India has done about it? So Supreme Court of India has given let's say guidelines to the central government and state governments. What are those guidelines? One of the guidelines says that the central government and state government should create a database, should create a record that which areas or which forests are recorded by the government as forest, right? So that should be properly classified and a record must be placed in front of the Supreme Court of India. And meanwhile, that the state government and central government is doing so, right, the definition of forest will be considered as is mentioned in the dictionary, right? So Supreme Court of India has reiterated the judgment in the T.N. Godavarman Thirumalpath case, okay? So it said that definition of forest will be as per the dictionary definition, right? Till the central government and state government comes up with a record, proper record related to this. So with this, now let us quickly move to another article. So this is another article. It says making sense of the electoral bond judgment through data. So let us quickly understand about electoral bond judgment. So what were electoral bonds? Electoral bonds were financial instruments through which Indian citizens and corporations in India could donate money to political parties. But there was this central government has come up with the electoral bonds scheme in the year of 2018. In the electoral bonds scheme, the central government of India has notified that these should be the eligibility of the parties, right, who will receive electoral bonds. So they said the parties must be registered, right, must be a registered party with the Election Commission of India, and it should have garnered 1% of all votes polled in the last general election, right? So that was the thing. Apart from this, the denomination of electoral bonds would be in 1,000, 10,000, 1 lakh, 10 lakh, 1 crore rupees, right? And a person who is donating to a political party, his identity will not be disclosed to the public, right? Only the bank officials will be knowing who has, let's say, donated to a political party through electoral bonds. And also on the electoral bonds, the name of the donee, a person who is donating, his name will not be mentioned. So the thing is, in this article, basically they have talked about some data points. They have talked about, let's say, which parties has received how much money through electoral bonds scheme. So here, let's say, there were few organizations that have filed cases in the Supreme Court of India. One of them is known as Association for Democratic Reforms, and there is a political party also, CPIM. So they have filed cases in the Supreme Court of India, and recently the Supreme Court of India has said that this is unconstitutional. The electoral bonds scheme is unconstitutional because it violates, let's say, right under Article 19 of the Constitution of India. It violates fundamental right of people under Article 19 clause 1 clause A of the Constitution of India. Okay, so this is the thing. So in this article they have given various tables. One of the table talks about income of national parties from known and unknown sources and their share in the total income of parties. Okay, so from electoral bonds, let's say, BJP was the party that has got maximum funding, maximum donation, right, from year to year. BJP has been the party, and Congress was the second maximum receiver of donation through electoral bonds. Apart from this, corporate donations received by national parties between financial year 17 and 22. So BJP has garnered huge amount of money. You see, Indian National Congress very less, CPI, Communist Party of India, Marxist very less, Nationalist Congress Party, I think, so it is also less. Okay, so these so the maximum amount of money has been received by BJP. So this is just a data point. It talks about which parties have received how much, let's say, funding through electoral bonds. So now let us quickly move to another article. This is again a short article. We are going to be quick. It says India Sri Lanka move forward with talks on trade agreement. Okay. So in the beginning of today's discussion, we started discussion with understanding the map of India and Sri Lanka. So as we know that Sri Lanka is a maritime neighbor of India. Okay, let me quickly draw the map okay, like map of India. Okay, this is map of India. This is where Sri Lanka is located. Okay, this is where Sri Lanka is located. So Sri Lanka is a maritime neighbor of India, and India maintains a very good tie with Sri Lanka. Okay, so there are historical ties also between India and Sri Lanka, civilizational ties, there are cultural ties, Buddhism ties between India and Sri Lanka. So now these two countries have, let's say, moved forward with trade agreements. And what is the name of the trade agreement? It is known as Economic and Trade Cooperation Agreement. Okay, economic and, so they are going to, let's say, start discussion on economic and trade cooperation agreement. And so in the next 2 rounds of bilateral talk scheduled later this month. Okay, so they are going to discuss on it. So when we refer to New Delhi, we refer to India. When we refer to Colombo, we refer to Sri Lanka. Okay, Colombo is the capital of Sri Lanka. As we discussed in the discussion today, Colombo is located to the western coast, okay, western side of Sri Lanka. Okay, Colombo is the capital of Sri Lanka, right? So here this is just a short article that talks about that both the countries have started negotiation. They are discussing and they are going to go further. They are going to move further with this particular agreement, which is known as Economic and Trade Cooperation Agreement. Okay, this is the thing. So further details are mentioned which are not needed, right, as of now. So with this is going to be the last topic for discussion today. It says South Africa accuses Israel of apartheid against Palestinians. Okay, South Africa. So we know South Africa is the country which is located in the African continent. It is located in southern portion of Africa. So what happens in South Africa basically? So South Africa basically has itself gone through a phase of apartheid. It has gone through a phase of apartheid. So apartheid is a kind of injustice that is done to, let's say, one group of people by a dominant group of people. For example, long back when Britishers were ruling on South Africa, so Britishers considered them to be superior, racially superior as compared to African people. So they imposed untouchability, they discriminated against South African people. But now what Israel is doing to Palestine can be categorized as apartheid. So South Africa has accused, right, Israel that it is doing apartheid against Palestinian people. Okay, so South Africa has later, let's say, previously moved to the International Court of Justice. It has moved to the International Court of Justice, right, with similar, let's say, accusation against Israel. And the International Court of Justice has given interim orders also in that regard. Okay, so this is the thing. So we know that a conflict is happening between Israel and Palestine, right, in the Gaza Strip. That's the thing. So that's all from my side for the day. Thank you so much everyone for attending today's session. I hope you have a good day ahead. Thank you.